Good day, everyone. Good day, sir. Today, I will be discussing some of the most important provisions in the revised rules of court criminal procedure, especially Rule 110 to 122, and we'll jump to Rule 126. These rules are the framework for the handling criminal cases in the Philippines, ensuring the proper administration of justice, so the protection of rights and adherence of due process. Rule 110, prosecution of offenses. Rule 110 establishes the basis of criminal prosecution. So, number 1, institution of criminal actions, section 1 to 3. Criminal actions are initiated either by filing a complaint or an information. B. For private crimes such as adulteries or concubinage, complaint must be filed by the offended party. Number 2. Sufficient of the complaint or information, section 6. It must state the name of the accused, the offense charge, and facts constituting offense, ensuring the clarity in the charges. Offenses must be prosecuted in the name of the state. Section 2. All criminal cases are prosecuted in the name of the people of the Philippines to signify the public interest. Rule 111, prosecution of civil action. So, number 1, the civil liability is implied. A. When a criminal action is filed, the civil action for damages is impliedly included unless the complainant waives, preserves, or institute it separately. Suspension of civil action. Section 2. The civil actions based on the same offense are suspended until the criminal action is resolved, avoiding conflicting judgments. So, Rule 112, preliminary investigation. This rule governs the preliminary investigation, which determines whether there is probable cause to file charges. Number 1, the right to preliminary investigation. Section 1, it is substantive right of the accused, particularly for offenses punishable by imprisonment of at least 6 years and 1 day. So, number 2, procedure, section 3. The complainant files a sworn complaint with supporting evidence. The respondent is given a chance to submit a counter affidavit, ensuring due process. Number 3, resolution. The investigating officer determines improbable cause exists, forwarding the case of prosecution if necessary. Rule 113, arrest. Definition of arrest. An arrest involves taking a person into custody in order to answer for a criminal offense. So there are different mode of arrest. So the one is by warrant issued by the competent court. So, and the second one is without a warrant, allowed under specific circumstances such as which the offense is committed in the presence of the officer or if it's a hot pursuit case. So, it be fitted in the 3 kinds of warrantless arrest. The number 1 is the caught in the act, and the hot pursuit, and the escape from the prison. Rights of the arrested. Section 9. An arrested person must be informed of the reasons to be arrested, to the arrest of their constitutional rights, including the right of remain silent and to counsel. Rule 114, bail. The right to bail. All persons have right to bail except for those charged with offenses punishable by reclusion perpetua or life imprisonment when the evidence the evidence of guilt is strong. Number 2, purpose of bail. Bail ensure the accused appearance in the court while balancing the presumption of innocence. Number 3, forms of bail, section 10. Recognizance, cash deposit, or surety bond. Rule 115, rights of the accused. Rule 115 emphasizes the rights of the accused, such as number 1, to be presumed innocent until proven guilty. Second, to be informed of the nature of the charges. Third, to have a speedy trial, speedy, impartial, and public trial. To meet witnesses face-to-face and to have compulsory process for obtaining favorable witnesses. That's all for the Rule 115. Next to the Rule 116, arraignment and plea. Arraignment, Section 1, the accused must personally appear and plead guilty or not guilty or nolo contendere or no contest. Requirements, the plea must be made voluntarily, intelligently, and with the assistance of the counsel. When plea of guilty to a capital offense, the court must require evidence to establish guilt and ensure that this plea is made knowingly. Rule 117, motion to quash. This rule allows the accused to challenge the complaint or information on legal grounds. A. The grounds for motion to quash. First, lack of jurisdiction over the offense. Second, failure to state an offense. The third one is double jeopardy. If granted, the case may be dismissed or corrected. Rule 118 to 122, trial, judgment, and appeal. So, pre-trial. Pre-trial, Rule 118 focuses on the plea bargaining, stipulation of facts, and marking of evidence to streamline proceedings. So, the trial, Rule 119, the prosecution presents its case first, followed by the defense. Both parties have the right to cross-examine witnesses. Third, judgment, Rule 120. Judgment must be in writing, state that the facts and law explains the court decisions clearly. Number 4 is the new trial or reconsideration from the Rule 121. A motion may be filed of errors of law, new evidence, and serious irregularities. So number 5, appeal, Rule 122. The accused or the prosecution may appeal the decision except when the accused is acquitted. So the accused of the prosecution may appeal the decision when the accused is acquitted. So let's jump to the Rule 126, the search and seizures. Lastly, Rule 126 governs search warrants and seizures. Search warrant, Section 1. A search warrant is an order issued by a judge directing law enforcement to search and seizures, a search for and seizes specific items. Number 2, requisite, Section 4. It must be based on a probable cause, personally determined by the judge after examining the complainant and witnesses under oath. So, it must be based on the probable cause. The third, exemptions of the search warrant requirement. Warrantless searches are allowed under specific instances, such as during a valid arrest or when consent is given. So, in revised rules of court, criminal procedure uphold fairness, protects the rights of individuals and ensure the efficient administration of justice by understanding the rules, particularly on prosecution, preliminary investigation, arrest, bail, and what else? Bail, search and seizures. We can appreciate how the justice system balances the interests of the state and the rights of the accused. So, thank you for listening, sir, and Merry Christmas and advance Happy New Year.